All right, good morning, everybody. It is Tuesday, April the 11th, 2023, and I'd like to call the Tennessee State Board of Funeral Directors and Embalmers meeting to order. Ms. Bohannon, if you'll call the roll, please.
Fred Berry,
Here.
Anthony Harris,
Here.
Tanya Scale-Haynes,
Here.
Christopher Lee,
Here.
Scotty Porsche,
Here.
Charles Rahm, Pam Stevens. Mr. President, we have a quorum.
Thank you, Ms. Bohannon. We will move to review and adopt our agenda for today.
Move we approve.
Second.
Motion by Mr. Berry to approve the agenda as presented, second by Mr. Lee. All in favor, say aye.
Aye.
Any opposed? All right. We have the minutes before us for the March 14th, 2023 meeting. Give you a moment to review those. We'll talk about any additions or corrections that need to be made.
Motion to approve the minutes.
Second.
All right. I have a motion by Mr. Lee, a second by Mr. Berry to approve the minutes as presented. Any further discussion? If not, all in favor say aye.
Aye.
Any opposed? All right. Good morning, Mr. Bryant. We'll turn to you for our legal report, please.
Good morning, board members. The first complaint is complaint number 2023-006771. Complainant, a former employee of respondent establishment, filed a complaint alleging unprofessional conduct. Specifically, complainant alleged that respondent aided and abetted unlicensed activity and other, quote, unethical business practices, end quote. Respondent stated that they were due to work their last day on February 14th, 2023. However, due to the alleged business practices, resigned as of February 10th, 2023. The owner replied on behalf of respondent establishment, stating that complainant was the former general manager of the respondent establishment. The owner stated that during complainant's tenure, he, the owner, was still in mortuary school and lacked a funeral director's license, and that while completing their apprenticeship at the respondent establishment, complainant signed off on the quarterly reports and, quote, rated them excellent in all categories on the final report, end quote. The owner attached a copy of this report as an attachment. The owner described complainant's duties as, quote, micromanaging every aspect of the staff, end quote, including disciplinary action against staff members, of which the owner states they hired 6 and fired 6 during their tenure and were, quote, heavily involved in all decisions relating to the funeral home, end quote. The owner stated that since they were unlicensed at the time, they would often defer to complainant judgment even if they disagreed with it. The owner stated that this resulted in losing several promising apprentices and assistants due to the complainant firing them or quitting because of the, quote, toxic work environment she created, end quote. The owner stated that complainant began looking for alternative employment whenever the owner received their license last summer. The owner said that though they intended to take the general manager position once it became vacant, the owner said they allowed complainant to remain the general manager while seeking other employment. The owner provided that complainant found alternative employment and put in their 2 weeks' notice at the end of January. However, the owner recalls that on February 9th, a family that complainant had worked with complained to a staff member regarding the services that complainant provided. During that conversation, the owner offered to assist with the services the next day. As respondent contends, the following day after the service was conducted, complainant confronted the owner as to why he had handled the services. The owner stated that they informed complainant of the family's complaint and contended that complainant then called him a liar and accused him of meddling with her client. The owner stated that this soon escalated to a heated exchange and that complainant left the property, and that soon after, complainant filed the complaint. The owner added that regarding allegations of unlicensed activity, that they have adequate licensed staff, 4 licensed funeral directors, 3 licensed pre-need sellers, and 4 licensed embalmers. The owner attached 9 letters from current and past employees of respondent establishment. Each employee corroborated the work environment as described by the owner and vouched that they were not aware of any unlicensed activity or unethical business practices as described by complainant. Complainant provided a rebuttal questioning the authenticity of some of the letters provided by the owner on behalf of respondent establishment. However, complainant did not further specify their allegations of unlicensed activity or unethical and unlawful activity with detailed or specific accounts. Based on the above, the bulk of the complaint appears to be work-related issues. However, for the remaining allegations, complainant does not provide specific accounts of unlicensed or unethical activity allegedly conducted by respondent establishment. In tandem with the documentation provided by the owner of respondent establishment corroborating their recollection of events, no evidence has been provided to support complainant's allegation. Therefore, we would recommend closure.
Just a quick question here. Do we have any information about the owner working the service Do we know, did he have a licensee with him, he or she?
My understanding is that at the point, which I think was February 9th or just before that of this year, the owner was licensed at that point. He was essentially waiting, kind of doing a due diligence to the complainant, since they've been in the general manager position, was waiting for them to find work. At that point, whenever the owner contends that they worked that service, they were licensed.
Motion to accept council's recommendation of closure.
Second.
All right, we have a motion by Mr. Lee to accept legal's recommendation of closure, second by Mr. Berry. Any further questions or discussion? If not, all in favor say aye.
Aye.
Any opposed? All right, number 2.
Next complaint is complaint number 2023-006771. Complainant, a licensed funeral director in Virginia, alleged that respondent was in arrears for several contracts for services rendered. Complainant stated that the outstanding invoices are from October 10th, 2022 through December 24th, 2022 for $25,595 in total. Complainant stated they have had a working relationship with respondent for years, and they have routinely had a running tab with them and have previously always been good for funds owed. Respondent replied stating that they had had some health issues which required them to be hospitalized in September of 2022 and to be on home health care for the month of October. Respondent stated due to his time out of the establishment, his staff took on additional responsibilities, resulting in this invoice falling through the cracks. Respondent stated they had an additional medical procedure during the month of November. Respondent further provided that the staff member in charge of filing the insurance contracted COVID in December, resulting in her missing work for 2.5 weeks. Respondent stated she returned in January and began filing insurance to receive the funds. Respondent confirmed that they have historically had a running tab with complainant and have always paid for services rendered. Respondent stated that the employee spoke with complainant and explained the situation and that they would provide payment as soon as possible. Respondent provided documentation to show that full payment had been rendered on February 16th, 2023. Respondent also offered health records of himself and the employee to show the period of extended leave both had experienced. On February 16, 2023, complainant contacted Centralized Complaints and requested that the complaint be withdrawn. Complainant confirmed that they had received payment in full and that this was the only time they had ever had to resort to filing a complaint. Based on the above, we would recommend closure.
Do we accept council's recommendation?
Second.
All right, we have a motion by Mr. Berry to accept legal's recommendation of closure, second by Mr. Lee. Any further discussion? Not everyone in favor say aye.
Aye.
Any opposed? All right, number 3.
Next complaint is complaint number 2023-008161. Complainant, daughter of the deceased, alleged that respondent establishment released the ashes of the deceased to a person who is not next of kin. Respondent stated that upon receiving the call for removal, he received approval and contracted with the sister of the deceased. Respondent continued that the sister contracted with them regarding a cremation, and that throughout the arrangement process he met with the sister of the decedent. Respondent stated that the services were carried out on March 1st, 2023, and that complainant called on March 9th, 2023. The manager was not at the office at the time of the call, so the call service requested that complainant call back the next day. The manager stated after being made aware of complainant's call, he called the sister of decedent who requested that respondent not release the remains to complainant and that she would send a representative to pick up the remains. Respondent stated the sister provided that there was a lot of contention within the family and that she was following the wishes of the decedent. Respondent stated the cremains were picked up by the representative of the decedent's sister and attached a form to show that the cremains had been released to the stated representative. The sister of the decedent also provided a written statement corroborating respondent's version of events. The sister specifically mentioned a difficult family dynamic and stated that respondent establishment did not contribute to that difficult dynamic. Furthermore, the sister reaffirmed that she had made the arrangements with respondent and that she had directly contracted with them and requested that the cremains not be released to anyone but her or her representative. The bulk of the complaint appears to be a family matter and issues involving next of kin determination. Based on the above, legal would suggest a closure with any remaining issues of next of kin determination to be determined by a court of competent jurisdiction.
Typically on these next of kin, issues, I guess consistently that we're saying that needs to be decided by another body or jurisdiction. Is that always the case if it appears on the, I guess it appears that what the statute states is the technical term, the levels of next of kin. Does this body not typically ever make a decision when there's a argument of who has the right of next of kin?
So I think when there's an issue potentially with the process, I know this board tackled one last month that kind of dealt with or a couple months ago about the process of determining next of kin, of asking, doing your due diligence, things like that. That I think is well within the board's purview. Excuse me, sorry. Where I think whenever there's a legal determination as to if there is a question kind of working through that statute that would require a judge to make that determination, that's where kind of the jurisdiction and authority of this board kind of hits its limit. Is that kind of here in this situation, what it seems like is that the complainant, both parties agree the complainant was not involved until March 9th, which was over a week after the services were conducted. So there are some questions about next of kin, about a certain amount of time in which to invoke those next of kin rights and things like that. When it starts getting outside of just the process and professional process of determining next of kin, that's where it kind of starts to bleed into more of a court of competent jurisdiction determination.
Yeah, I understand, because there's all kinds of factors that can enter into the situation versus just whether one's a child, one's a sibling, or what it does. So, thanks.
Another question here: do we know if the sister was a durable POA? Did the director ask if there were children? Do we know any of that?
That information wasn't provided, but from reading the complainant's complaint, the issue that they had was not that they weren't involved in making the arrangements or that they weren't notified. It's just that it seems like they kind of wanted to come in at the end of the process and take the cremains essentially. And that up until this point, I'm trying to recall when the removal call was made, but it was a little bit before the services were done. So essentially the complainant kind of pops up at the very end, having not had any interaction with the respondent up until that point.
So the funeral director, pretty much based on good faith, did everything that he should have done. So.
Other questions?
More questions that one could ask to determine, but that's why I'm
with
a little hesitant.
I almost struggle that maybe the director didn't do the part of trying to find out, was there children? Were there more here? It's almost like he or she just met with the sister and let the sister make those decisions. Maybe I'm wrong in maybe understanding that, but that's almost the way this comes across.
And I think, too, throughout, since the sister said specifically that there are difficult family dynamics at play, I'm not certain it wasn't included in the complaint or in the respondent's reply or the sister's narrative. I guess all that to say we don't have evidence of that one way or the other.
So the complaint doesn't involve the cremation itself, I'm guessing. So we don't know that the daughter didn't sign authorization.
And likewise, as I alluded to earlier, there is a statute that if you are in that statute, kind of in the pecking order of next of kin, if you're in line and you don't invoke that next of kin within, I'm trying to recall if it's a week or 72 hours, but if you don't do it within that time, then you forfeit it. And I think in this circumstance, again, that's kind of, if the complainant had an argument that no, I did come forward, that's again where I think we start getting into court of competent jurisdiction determination. But I don't know if that makes you feel better or not. But all that to say that since they didn't come forward for well over a week from when these were the kind of the arrangements were beginning to be made and services were provided, I think there's a strong argument that was that next of kin determination was forfeited.
On some of these, it'd be interesting to see, like cremation authorization forms specifying who the next of kin is, and if it, if the authorized representative is signing like that they are the next of kin, then the funeral director is acting in good faith, and you've got documentation there to prove that. But I do understand those other factors, like how much time goes by that nobody steps forward and things like that. So, I guess in these situations, do we ask for any of the documentation to be provided, like the cremation authorization form, or?
We can. I know sometimes the complainant provides it or the respondent provides it, and sometimes they don't. It just kind of depends on the matter. So I guess in this circumstance it wasn't provided, but what was provided essentially was that the sister of the decedent's narrative, essentially kind of walking through of it very difficult family dynamics. It was just me, and I was trying to carry out the wishes as they were conveyed to me.
Do we know the window of when the authorization was signed and from the date of death to when the cremation took place?
From my recollection, I don't believe that was within that was communicated in the information we have. But what I do recall, I'm hesitant to use specific dates because I don't want to say the wrong one, but it was a relatively short period of time that the sister of the decedent made the removal call, and that within a fairly short period, I know in the narrative they communicated that they had some financial troubles getting all the money together, and that respondent was very helpful in working with them on that. So that delayed it just a little bit, but it was a relatively short time period of the removal and from getting the proceedings started.
I'm like Mr. Berry. I think we're missing some pieces here to make in my opinion, to make a good decision whether the director did he or she's part, or just let that sister roll with it. So that's just my opinion.
Might be worth consideration that in situations like that we try to collect. Does that if you are trying to collect documentation like that, does that trigger an investigator having to go get that, or can
not necessarily? I can usually it's as easy as sending an email requesting it, and they can just email it and I upload it to the file. It doesn't usually require an investigator to be involved, but if it's kind of, I guess, technical documentation or something they may not feel comfortable just emailing, then we may send an investigator out there to pick it up themselves.
The cremation authorization is just a very valuable document to look or to review. With cremation, it becomes more difficult on a traditional service really to determine questions to ask and regarding who has the right and who is the proper next of kin. But on cremation, you have more documentation to try to make sure that you are dealing with the right person. So it may be something good to start requesting that we're actually able to review those, or the department's able to review those and then let us know what any findings that are there. So I'd just be very curious to know what was on that authorization form, as if who were the next of kin other than the sister. So I guess we can move forward with recommending council's recommendation, or we could come back and ask for additional documentation if we felt.
I think we need to ask for more documentation because I want to make sure, in my opinion, that the director has done their due diligence here. That's my opinion on it, but I'll go with you guys and gals.
How would that, so if we were going to request to see the cremation authorization document, how would we just present that in the form of a motion and take this up hopefully next month?
Yeah, so the motion would be, I would think, just in the form of to conduct, I mean, you can say additional investigation. An investigation can include me just sending an email and trying to get that documentation. And then assuming I'm able to get that within, if I don't have to send someone out to get it, we should be able to have it next month for certain. But that's a little dependent on outside factors, but that would be the form of the motion.
I just think what we're looking for in simplicity is how the sister got ahead of the daughter. I mean, that's simple. It could be a waiver, it could be a POA or anything. I think that would answer every question in a nutshell, I believe.
I'd make a motion that we request additional investigation for documentation to be provided from the establishment, which would be the cremation authorization or any other document supporting how the decision was made that the sister had the right to sign the authorizations. So that would be my motion, and that would be brought back at the next meeting to put a timetable on it.
Okay, we have a motion by Mr. Berry to ask for additional investigation for documentation to determine the next of kin that was used on this and to have that brought back at our next meeting. Do we have a second?
I'll second.
Second by Ms. Haynes. Any further discussion or questions? If not, all in favor, say aye.
Aye.
Any opposed? All right. Number 4.
Next complaint is complaint number 2023-007011. Complainant alleged unprofessional conduct on behalf of respondent establishment. Specifically, complainant alleged that during the arrangement process, the prices changed several times, and they were allegedly told that if they paid cash, the price would be reduced. Complainant further alleged that they picked a black casket on the day of the service, and on the day of the service, the casket was blue. Complainant alleged that respondent claimed that, quote, they were out of black caskets, end quote. Complainant finally alleged that when they received their bill, the name on the bill did not match the employee they had worked with. Complainant alleges that they had called the employee they worked with several times in order to speak to the owner, but claims that the employee did not allow them to speak to the owner. Respondent replied stating that the issues in the complaint were never brought up by telephone or in person by any family to any staff or management at respondent establishment. Respondent theorized that the complaint may be fraudulent and provided the following information in support of that claim. First, the respondent points out that complainant did not mention the name of the deceased. Legal can confirm that complainant did not provide the name of the decedent. Further, respondent stated that when looking at the name of the complainant when reviewing their records, no one from respondent establishment recalls working or speaking with anyone by that name on or around the date of the incident, February 1st, 2023. Additionally, respondent searched records to see if complainant was listed in their system as a family member to any service decedents, which she was not. Respondent provided an attachment to show this. Furthermore, respondent also searched for decedents serviced with the last name of complainant, since complainant claimed to be the deceased sister, and found no decedents with that last name who passed on or around February 1st, 2023. Respondent also provided an attachment to show this. Second, respondent pointed out that complainant failed to leave a phone number on the complainant form and provided an incorrect address. Respondent stated that they performed a Google search of the address provided, which provided 0 results. Additionally, respondent stated that even when giving complainant the benefit of the doubt, by Google correcting the address from avenue to street, complainant's provided address listed the address as an avenue rather than a street. The street address has no homes and is only vacant lots. Respondent provided an attachment to show this as well. The only contact information complainant provided was an email address. Legal emailed complainant on March 29, 2023, requesting that they contact legal. To date, complainant has not contacted legal. Based on the above, complainant has not carried their burden in their complaint against respondent, and therefore we would recommend closure.
Questions for legal?
Just a question for my knowledge. When one files a complaint, is there's certain requirements that must be mentioned, or is there kind of a boilerplate form that would ask for the decedent's name, date of death, things like that, or?
Not necessarily. There is some information. It is a stock form that you fill out. Generally, though, that information is the information of the complainant, which, again, in this case, they left blank mostly. It's not, I'll put it this way. There's nothing in place that they ignored in black and white that said, what is the decedent's name? What was the date of death? Things like that. There's nothing like that in that form. But it is, from all the complaints I've seen in the year and a half I've been here, it is very unusual to not mention that information.
Sure. I was just wondering.
Sure.
I'll make a motion that we accept council's recommendation for closure.
Second.
All right, we have a motion by Mr. Berry to accept legal's recommendation of closure, second by Mrs. Stevens, I believe. Any further questions? All in favor, say aye.
Aye.
Any opposed? All right, looks like we've got about 5 here together, number 5, 6, 7, 8, and 9.
Okay. Next one is a bit of a novella. So if you have any questions, that I imagine there will be plenty, and that's okay. So complaints 5, 6, 7, 8, and 9, 2023 00 2071, 2023 00 2091, 2023 00 2111, 2023 00 2131, and 2023 00 2151. Complainant, an employee of respondent establishment number 1 and 2, alleged that while in the cooler room in establishment 1, she discovered a box containing human viscera in the crematory area. Complainant clarified that though she was an employee of the business that owned this establishment, she was not usually stationed at this location. Upon her arrival, she began cleaning the establishment in the crematory area. Complainant stated she discovered a box with respondent establishment 3's name on it, with the name of a decedent and a date of 7/7/21 written on it. Due to its weight, complainant recruited another employee to help her lift the box. Complainant asked the employee if they knew what was in the box, and he stated he did not, and that he rarely went into this room because the door was always closed. Complainant stated that they tore the tape off the box and realized that there was human viscera within the box and retaped it. Complainant called funeral establishment number 3 and asked them about the box. Complainant number 3 stated according to their records, it was from an embalming they had done for funeral establishment number 2, and they had given them the box when the decedent was returned to establishment number 2. Complainant then called the manager of establishment 2, respondent funeral director in these slew of complaints, and asked if he was familiar with the decedent listed on the box. Complainant stated the respondent funeral director indicated he was familiar with the decedent as he had done the decedent's funeral and buried him in July of 2021. Respondent further indicated he would have an employee come by and pick it up later. Complainant stated that she did not hear anything else regarding the viscera, so she brought it to the president of the company's attention on December 30th. Due to personal leave, complainant stated that they would not be back to work until January 9th, but that the president assured complainant that it would be handled before she returned to work. On January 9th, complainant stated that they asked the employee who was supposed to pick up the viscera whether it was still at establishment number 1. Complainant contends he said that it was, but that he was waiting to be told where to take it to. Complainant filed the complaint 2 days later on January 11th, 2023. Due to the nature of the allegations, the department sent this case for investigation. On January 12th, 2023, 2 investigators arrived at respondent establishment number 1, where the viscera was purported to remain. The 2 investigators made a thorough inspection of all areas of the establishment, including outside trash receptacles and areas outside the building. The investigators did not discover the box of viscera on the premises of the establishment. After speaking to an employee, the investigators discovered that the box of viscera had been relocated to a local crematory so that the viscera could be cremated. The investigators next traveled to establishment number 2 and spoke to the manager, who is the respondent funeral director. Respondent provided additional context stating that the body of the decedent had started at a separate establishment for holding because the family was not sure whether they wanted a direct cremation or to have the body embalmed with a funeral ceremony. Respondent explained that the establishment holding the decedent did embalming services for respondent establishment number 2. Respondent stated that the body was not embalmed while there because the family had not given permission to embalm. Soon after, the family of the decedent decided to use Respondent Establishment 3 instead, so the decedent was removed to that establishment. Soon after, the family again decided to move the decedent back to Respondent Establishment 2. However, Establishment 3 had already embalmed the decedent. As such, Establishment 2 paid Establishment 3 for removal and embalming services. The decedent had their services performed at Establishment 2, and the burial was performed soon after at a nearby cemetery. Respondent stated that in late December of 2022, they were informed by complainant that the decedent's viscera had been discovered. Respondent stated that following the discovery, he tried to get in touch with the family of the decedent to let them know, and after several tries due to a changed phone number, Respondent visited the family's home to inform them about what they had found. Respondent stated that he explained to the family their options for disposal of the viscera and that he communicated to the family he would take full responsibility for the mistake. Eventually, after a good deal of discussion, the family decided to have the viscera cremated and scattered at the grave of the decedent. Respondent stated that the cremation authorization form was signed on January 5, 2023. The viscera was picked up on January 6, 2023 by an employee of the crematory. Respondent further provided that he was planning to pick up the decedent's family on either January 16th or 17th to transport them to the cemetery and assist with scattering the ashes, and stated there would be no additional charge to the family. Soon after, the investigator was sent out to obtain more detailed statement from complainant and all named respondents. The investigator met again with complainant, who largely reiterated what had been stated in their complaint. Next, the investigator met with the office manager of Respondent Establishment 3, the establishment who embalmed the decedent. The office manager reiterated that originally the decedent had been at Establishment 2, but was transferred to Establishment 3 on July 7, 2021, and the decedent was embalmed on the same day. However, later that evening, after several family members of the decedent requested that the decedent be returned to Establishment 2, the decedent was again removed to Establishment 2 on July 8, 2021, and Establishment 3 was compensated for the removal and embalming. The office manager recalled that the person who made the removal for Establishment 2 took the box containing the biohazard bag containing the viscera, but could not recall the name of the removal person. The manager provided that on December 20th, 2022, she received a call from the complainant inquiring about the box of viscera discovered at Establishment 1 with Establishment 3's name written on it. Complainant provided pictures of the box to the office manager. The office manager stated she confirmed with complainant after pulling the file for the decedent that someone from Establishment 2 had picked up the decedent in the box back in July of 2021, and that complainant would need to check with Establishment 2. The investigator asked the office manager the procedure in dealing with viscera following an embalming. The office manager stated that the viscera was placed in a bag and then placed in a box. If the body was to be buried, the box was placed between the decedent's legs and the casket, and if the body was to be cremated, the box was placed in the cremation container and cremated with the body. Next, the investigator met with the embalmer who performed the embalming of the decedent. First, the investigator asked the embalmer whether he recalled embalming the decedent on July 7, 2021. The embalmer stated that he did and provided that the decedent was an autopsied case. The investigator showed the embalmer photographs of the box complainant had taken, and the embalmer stated that it appeared to be his handwriting on the box. The embalmer provided that he left the body of the decedent with the box of viscera on top of the body for the removal person upon their arrival, but said that he was not present at the establishment when the decedent was removed. The embalmer stated that after embalming and suturing the deceased, his method to place the organs in a box and seal it with tape, write the name of the deceased, date of embalming, and the name of the funeral home on the box. Then, the box would be placed in the foot portion of the casket below the mattress and springs. The embalmer stated that in their experience, in most cases, the viscera would not fit back in the body cavity of a decedent who had been autopsied, so in these instances, the organs would be placed in the box following treatment. Next, the investigator met with the funeral director manager of Establishment 2 to follow up regarding respondents' interactions with the decedent's family. Respondent provided that he met the family on January 17, 2023, at the cemetery and scattered the cremains of the decedent. Respondent provided a document signed by one of the family members verifying that the cremains had been scattered. The investigator asked the respondent about Establishment 2's process for treating the viscera of an autopsy decedent. Respondent prefaced that they were not a licensed embalmer, but the embalmer for Establishment 2 would treat the viscera and place the viscera back in the body. If it was unable to be returned to the body cavity, the embalmer would notify him after the dressing and casketing of the deceased, and the viscera would be placed in a container at the foot of the casket. The respondent said that he and another employee did dress and casket the decedent, but that there was no viscera present with the body. Respondent stated he was not sure what delivery person brought the body of the decedent from Establishment 3 to Establishment 2. Finally, the investigator spoke to the family, specifically the mother of the decedent. The mother provided that she wanted to use Establishment 2 and the respondent funeral director and contacted them to pick up the decedent. At some point, it was recommended to her to use Establishment 3, and she agreed to have the decedent removed. However, following the decedent's removal, the mother stated that some family members were upset and did not want to use Establishment 3, so she agreed to have the decedent returned to Establishment 2. The mother stated the visitation and funeral services were conducted at Establishment 2 on July 12, 2021. On January 5, 2023, the mother called the respondent funeral director, recalled that the respondent funeral director came to their residence and informed her and her husband that the decedent's organs had been found and were not buried in July of 2021. The mother stated at respondent funeral director's suggestion, they agreed to have the organs cremated and to scatter the ashes on the decedent's grave. The mother stated that she signed all cremation paperwork granting permission for the organ's cremation. On January 17, 2023, she, her husband, and friend met respondent funeral director at the cemetery and scattered the cremated remains on his grave. The mother stated the respondent funeral director accepted full responsibility for the error. Based on the above, legal would state the following. Establishment number 1, a violation of professional conduct regarding the box of viscera that had remained at the establishment following the burial of the decedent. Establishment number 2, unprofessional conduct for the employee agent of respondent establishment for the driver responsible for the removal of the decedent and box of viscera. The viscera, along with decedent, was to be returned to establishment number 2, but respondent's driver and agent did not deliver the viscera to establishment 2. So based on all of that, would recommend for funeral establishment 1, the location where the viscera was discovered, a $1,000 civil penalty plus half of the cost of investigation to be authorized via consent order and formal hearing. Establishment number 2, who had the driver, whose agent it was, and responsibility to go pick up the body of the decedent and the viscera and deliver it back to establishment 2, a $250 civil penalty plus half the cost of investigation to be authorized via consent order and a formal hearing if necessary. And for funeral establishment 3, who conducted the embalming, the respondent funeral director, and the embalmer, letters of warning. And I'm sure there are plenty of questions.
That?
Sure.
I know that's a lot of information for all of us to soak in.
Mr. Lee, do you want me to just take it from the top? Or?
I'll waive that. Thank you.
First of all, thank you for a great detailed report
Yes.
there. Do we know the job title of the complainant by chance?
The complainant is a funeral director.
I remember several years back, this board tackled a case about the viscera being in a box. I know there's a lot of discussion and back and forth. It's been a few years back. I'm guessing a precedent was set with that. That's not the violation here with it being in the box. The violation is it being neglected or whatever, I'm assuming.
Correct. Yes. Essentially, that what appears to have happened from all the evidence we gathered is that some shifting back and forth from the family, which is totally fine. And so the employee of this establishment 2 had the duty to go pick up the decedent and the viscera. Establishment 1 and 2 were owned by the same parent company. So I think logically what probably happened is the decedent and the box of viscera were supposed to make it to establishment 2. The decedent did. The box, for whatever reason, did not, and ended up at establishment 1, where it essentially sat for some time.
I don't know, maybe I'm wrong on my thinking, but many years in this business, I've never heard of doing anything but treating the viscera and putting it back in the abdomen where it goes. I've never heard of placing in a box. Maybe I'm different on this. If the complainant hadn't have brought this up 2 years later, would it still be neglected, do we think?
So from my understanding, the complainant was sent there with the specific purpose of, I guess, organizing everything at that location. So I don't want to. I'm trying to think of the correct way to say it, but essentially it was a act of the establishment that essentially discovered it. It wasn't necessarily just happenstance. That person was sent there with the purpose of organizing and tidying things up. But to answer your question, if that employee wasn't sent there, I think at this point, kind of this was the window of it to be discovered, that it would have been. It was just a matter of when, not if necessarily.
So when was an embalming authorization completed and signed? At what stage of this?
That would have been back in 2021.
No, I mean as far as which establishment was the embalming authorization?
Gotcha.
Did it originate?
I'm not entirely certain of that. I think from what I've gathered here, from the information provided, everything on the front end back in 2021 seems to have been done correctly, with the exception of the viscera not ending up to where it was supposed to go. I do know the family, even what they communicated to our investigator, that they were, due to kind of a lot of familial opinions, a little indecisive on where to go. But I think all the paperwork on the front end, the embalming authorization, and all of that was done correctly. There was no evidence to show that it was there were any violations on that end.
So I have a quick question. And you may have said this, but all three of these establishments are tied together through the same organization?
1 and 2 are tied together with the same parent company. 3 is a separate one.
And according to this, number 3 was compensated for the removal and embalming.
Correct.
Okay. But then they didn't use number 3.
Great. Went back to number 2.
Yeah. So they were compensated for the removal from establishment 2, where it started. So I know it's confusing, and not being able to use names makes it harder, but so it started out at establishment 2. The family decided we'd rather use 3. So they went to 3, where they embalmed, and then the family came back and said, actually, we changed our minds. We'd rather use establishment 2. So 3 was compensated for the removal from 2 to 3, and then the embalming, and then it went back to 2 from there.
3 and 2 do not have a ownership tie.
Correct. They do not.
Body was back and forth between 2 and 3, but
Correct.
the viscera ended up at 1.
Correct.
I'd assume that 3 never asked where they were, where the viscera, when they did the embalming process. So whoever started, if there was any treatment of that, that's why I'm asking about the embalming authorization, and did number 1 have embalming authorization to even to do anything with the viscera?
So establishment 3 did the treatment and embalming of the viscera. So whenever they received the decedent, establishment 3 is the one who, the embalming had not been done yet. So establishment 3 did the embalming.
So establishment 3 did have possession of the viscera then?
Correct. And then, so whenever the family changed their minds again and said, okay, we're going to go back to 2. Establishment 3, you've embalmed the viscera. Thank you. We appreciate that. Here's compensation. They had the decedent, and according to the embalmer's statement, they had treated the viscera and had it in its container ready to go, and they put the box of the viscera on top of on the table with the decedent. So then when employee of establishment 2 comes to pick it up, they take the decedent and they take the box, and with the marching orders of delivering both back to establishment 2. And what appears to have happened is the decedent made it to establishment 2. The box did not. The box made it to establishment 1 instead.
Oh, so the box was taken from 3 to 1.
Correct.
Body from 3.
But one I guess one would know that they had received just viscera, which would be very unusual.
Is there a reason? Maybe I'm looking at this wrong, but establishment 2, there's nothing against the embalmer here. It's against the establishment. I feel like we're missing that piece of
Well, the embalmer was
at 3. That's right. Yeah.
Establishment 2 just provided a transport to pick the body and the viscera up.
Establishment 2 took responsibility for it.
Correct.
It was in your comments that took full responsibility, and they're the one who sent a driver to Establishment 3 to bring both the deceased and the viscera into their.
Yeah, I guess specifically the respondent funeral director, who is the manager of Establishment 2, said that he would take full responsibility for it. But that's correct. That Establishment 2, where they play into this, is that, or I guess in legal's opinion, their violation is that they sent the driver who made the mistake of not keeping the decedent and the viscera together.
See how that could happen if they're separated.
So is there not a reason something's not against an embalmer here? Everything looks like it's going against a establishment, and all we're doing is a letter of warning on the embalmer. It looks like there's, to me, a lot of negligence here. Maybe that's my opinion.
I think for the embalmer, the 2 points that I reviewed the statutes and the rules very carefully is that I think there are 2 potential points. One is the ability or inability to return the viscera to the body cavity. What's difficult with that is that it was an embalmment done a year and a half ago, where the only essential eyes on it were the embalmer and the establishment that they worked with. So what's difficult in that as a violation is we don't necessarily have it becomes a little bit of he said she said of the decedent was autopsied. I tried to return the viscera. I couldn't do it. I'm sorry. And there's just no way for the investigator for a year and a half old embalming situation to have evidence to say, no, actually here's where you fell short. The other issue that we talked about considerably was the a non-porous container for the human viscera. So the embalmer stated specifically that they put it within a plastic bag and treated it, did everything presumably you're supposed to, and then put it in the cardboard box knowing that it would be transported back to a different establishment. The question of whether a plastic bag is a container spent up more hours than I would care to admit as to one of those very specific legal determinations. So I think from legal's perspective, those are the 2 questions of did the embalmer go wrong here? As far as the responsibility of it getting back to where it needed to go, that falls on Establishment 2 essentially, because it was their delivery person, their removal person who was in charge of essentially the embalmer put it in the box, teed it up for the removal person to take it back, and it did not make it back.
We know for a fact that Establishment 2 knew the viscera were separated, and there were specific instructions for the driver to bring both of them back. Establishment 2 had knowledge, because if they didn't, it'd be easy for Establishment 2 to pick up the deceased and assume nothing.
To my understanding, from what I know, they did not have specific knowledge at the time when they sent their person to go pick it up. It wasn't specific instructions of, when you walk in that room, you're going to see a decedent, you're going to see a box. We need both. I don't know for certain that the instructions were that specific.
If that's the case, it seems like the more of the responsibility is on Establishment 3.
3 for the embalmer.
The embalmer and establishment both. But if we do not know, if Establishment 3 doesn't have documentation or indicating that they specifically told Establishment 2 that there was this separation, and when you come, be prepared to take the decedent and the viscera. But it seems, based on the knowledge that we have, that Establishment 3, there's more liability with them to make sure that when the decedent was picked up, that both the viscera and the decedent was picked up versus Establishment 2. In
Back
my
on
opinion.
page 1, it's when they picked the box, found the box. It had the decedent's name, the date of death, and establishment number 3. In my mind, I think I'm seeing him arriving there, picking both of them up, and when he delivers it to establishment number 2, he forgets to take the box out, and he probably goes back to establishment 1 and puts it in the cooler. I know that's a lot of what ifs, but I'm just trying to follow, because 1 and 2 are under the same parent company, so that guy probably works for both and interacts with both and makes removals for both. So
I think I'm struggling with just a letter of warning on Establishment 3, because really that's where it all began. Is there a reason why just a letter of warning on them?
Essentially on that one is, so I understand what the board's saying on if and I agree that piece of information would be helpful. I don't know in the investigation that ever came up specifically if when the removal person for Establishment 2 walked in there, if they knew they were going to had specific instructions to find 2 separate things. I don't know that question was ever answered. Because of that, not having specific evidence as to a violation, I guess from Respondent Establishment's perspective, they got the decedent from Establishment 2, brought it back, embalmed had their employee embalm the decedent, and were told, hey, family changed our mind, we need to go back to 2. And then they, again, kind of teed everything up to have the removal person for 2 take the decedent and the box back. From my perspective, that was essentially the extent of Establishment 3's responsibilities.
I want to applaud you for memorizing all this stuff and helping
No
us
doubt.
muddle through it.
I apologize. I tried to make it as, I know 3 establishments, not being able to use names makes it so difficult. And so thank all of you for sticking with me on it. I know it's a lot to go through.
Since ceased and the viscera left Establishment 3, again, you can question whether what should have happened with the viscera at 3. And clearly, if the driver picked it up, then the liability with what happened after that point involves the ownership of 1 and 2. So back to the recommendation.
And I think what I see exactly what you're saying, Fred. I think what pushed me over is the box actually had the decedent's name and everything on it. So it wasn't just like a random box. That's where I was having my trouble.
And for Establishment 1 to take those back into possession without a lot of due diligence, that's obviously an issue. So personally, I'm okay with the recommendations for Establishment 1 and 2. I don't know if there needs to be any more discussion on 3 about their processes or not.
Do we need to take these one at a time with the recommendations for disciplinary action?
I would, just for probably clarity and simplicity's sake, but the only thing, I guess, with the caveat on that is if when we get to Funeral Establishment 3, funeral director or the embalmer, if the board does opt to do a civil penalty for any of those, just that the investigation costs be divided equally. So for example, not saying that this is the motion or what you would do, but if you did decide to do funeral establishment 3 a civil penalty as well, then the recommendation for establishment 1 and 2 would be amended to be that number plus 1/3 of the investigation costs.
Now, is the funeral director the one from establishment 2?
Correct.
Okay.
Yes.
I just want to make sure I followed that.
And is there a bad rule if we dealt with number 3 first and sort of go backwards?
Yeah,
That way we don't have to do a bunch of amendments.
Yeah, I think that would be totally fine.
All right, so let's tackle funeral establishment number 3, and then we'll go from there. Other questions on establishment 3 or have a motion on it?
What is the letter of warning concerning establishment 3?
So essentially, the letter of warning would be on because I agree. The question on, sorry,
It's okay. No, look,
we're on 3, but since the embalmer is the employee of 3, so it's a closed question on whether, for purposes of transportation, the plastic bag is enough for human viscera, and it's just kind of this is very close, a letter of warning. So it's
okay. That helps me right
Okay.
there. That helps me.
Also, was there a statement in there that embalmer at number 3 stated that oftentimes the viscera would not fit, or just on this one particular case?
from my understanding, and it seemed like he said that with autopsied decedents who came through, it was that they frequently had difficulty returning it.
Typically, when you're dealing with them, so that's a interesting statement to be made by an embalmer, I think. So,
It's like a
So
easy way.
I explain things very simplistic. I think everybody's pregnant in this deal. I mean, I think everybody has a responsibility. I mean, that's my opinion. Maybe not pregnant, but everybody has a responsibility. I'm going to make a recommendation that establishment 3 have a civil penalty of $250 because the bottom line is it is the establishment's responsibility.
I'll second that.
Okay. Just so I understand, we're leaving the letter of warnings on the funeral director and embalmers.
That's correct. And I guess I'll need to add to that
Cost of investigation.
the cost of the third of a cost of investigation. Is that right? Is my math right?
Correct. And I'll second that.
Okay. So we have a motion by Ms. Stevens on funeral establishment number 3 to change from the letter of warning to $150 civil penalty. $250. Is that not what I said?
I thought you said one.
I may have. $250 civil penalty with a third cost of investigation, authorizing via consent order a formal hearing if necessary, leaving a letter of warning on the funeral director and letter of warning on embalmer. We had a second by Mr. Berry. Any further discussion on funeral establishment 3?
And that fine is for the.
Funeral establishment.
I mean, I'm talking about what it's for. Is it the way they boxed, or you saying there was no attempt made? I guess I just want to make sure of what we're fining them for. Was it for not putting the viscera back in the body, or was it for the legal edge of in a bag in a box, or?
I personally think they should have been returned.
I
Okay,
absolutely
that's what
agree
y'all were
with
saying.
that.
Okay,
Yep. It's almost negligence on their part.
I just want to make sure I was.
Yeah. Any further questions here on establishment 3? If not, all in favor with the motion, say aye. Any opposed? All right. So let's just keep going backwards. Establishment number 2, we have before us the $250 civil penalty plus the half cost of investigation, authorizing a via consent order and formal hearing. Any questions on it or a motion?
Establishment 2.
Yes, sir.
All right. Do we need to change that to 1/3 of the cost now? Right.
Yes.
Correct.
I'll make a motion. We accept council's recommendation of a $250 civil penalty and alter the cost of investigation to 1/3.
Second.
All right. I have a motion by Mr. Lee on establishment number 2 for the $250 civil penalty to stand, but changing the investigation cost to 1/3, authorizing the via consent order and formal hearing if necessary. Any further discussion on establishment 2? If not, all in favor say aye.
Aye.
Any opposed? All right. Moving on to funeral establishment number 1. It lays before us $1,000 civil penalty. As it stands now, half the cost. We would need to alter that and the consent order. Any questions or a motion?
Motion to accept council recommendation of a $1,000 civil penalty plus 1/3 cost of investigation.
Second.
All right. We have a motion by Mr. Lee to accept legal's recommendation on funeral establishment number 1, $1,000 civil penalty, and changing the cost of investigation to 1/3, authorizing the via consent order and formal hearing if necessary. Any further questions on establishment number 1? If not, all in favor say aye.
Aye.
Any opposed? Mr. Bryant, thank you again for due diligence there. And we will move to number 10 when you're ready.
And I think it was potentially addressed, but just for I think it was kind of in the bulk of a larger motion, but just to be safe, if we could individual motions on the funeral director and embalmer, for which we have a letter of warning
Okay.
as the recommendation.
So under establishment number 3, we need a motion to accept legal's recommendation for a letter of warning.
That would be that one was amended to 250 and 1/3, and
Okay.
so it would be the motion for funeral director and embalmer.
Okay. So we need a motion there on the funeral director under establishment 3 for a letter of warning. Do we have a motion for that one?
So moved.
Second.
All right. We have a motion by Mr. Lee to accept the letter of warning on the funeral director under establishment 3, second by Ms. Stevens. Questions?
Just a question. So the funeral director is 3 or 2?
Funeral director's under
3.
The funeral
No,
director,
two.
yeah.
Funeral
So
director's 2.
the
The
funeral
funeral
director
director should be under 2, I think.
yes, and the embalmer is
Under
with
3.
establishment 3.
Thanks for clearing that one. All right. So the motion for the funeral director letter of warning is for the funeral director under establishment 2. Motion by Mr. Lee to accept legal's recommendation, and I think
Second.
Okay, second by Mr. Berry. Any further questions on that one? All right, all in favor say aye.
Aye.
All right, and let's, any opposed? We'll move to the embalmer, who falls under establishment number 3. Legal's recommendation, letter of warning. Do we have a motion for that one?
For approval.
All right,
Second.
have a motion by Ms. Stevens, second by Mr. Berry. Any further questions on that one? All in favor say aye.
Aye.
Any opposed? Again, Mr. Bryant, thank you. We'll move to number 10.
So the good news is hopefully it's all downhill after that if we get a more complicated one. So next one is complaint number 10, 2023-009-411. Complainant, a licensed funeral director, alleged unprofessional conduct on behalf of respondent funeral director. Specifically, complainant stated that on February 14th, 2023, they made arrangements for a decedent, and during that process, the decedent's daughter provided a deed and contract showing an outer burial container and an opening closing for fees prepaid to a cemetery. However, the phone number to the cemetery was not working. Complainant stated that they called a funeral home in the same city as the cemetery and inquired about a contact. Complainant alleges that they were told that they would have to go through the funeral home, the one complainant had called, to schedule a burial at the cemetery. Complainant stated they scheduled the burial and faxed the contract to the funeral home and confirmed that it had been received. Complainant stated that they requested to be contacted if there were any questions regarding the provided documentation, and complainant stated they never received a call. On February 17th, 2023, complainant stated they traveled to the cemetery for the burial. However, upon arrival, a grave had been opened up, but no burial container had been set up. Complainant stated they called the funeral home and were allegedly told by a funeral director, quote, "It sounds like you have a problem," end quote. Complainant called respondent, who stated that the call center had only told her that the grave needed to be opened. Complainant stated that respondent explained the circumstances around the cemetery being abandoned and that the funeral home only handles scheduling burials and arranging the opening and closings of graves. Complainant stated that had they been made aware of the status of the cemetery up front, the issue could have been resolved. Respondent replied, supplying larger context for the history of the cemetery. Respondent stated that in March of 2013, the owner of the cemetery passed away and left the cemetery to his son. Respondent stated that the son was in control of it for more than a year, but, quote, due to gross mismanagement on part of his father, end quote, the son was not able to continue. The son ultimately walked away from the cemetery, leaving it to the state of Tennessee. Soon after, respondents stated they were contacted by burial services requesting to be put in touch with property owners willing to assume its management as a nonprofit entity. However, several years ago, due to additional hard times, the cemetery was taken over by a bankruptcy court. Respondents stated the funeral home was asked by the court to help them run the cemetery by marking graves and arranging openings and closings. Respondent agreed and stated that since that time, they have received no help or assistance from the court and have received no compensation for their work. Respondent stated that in the case at hand, they were contacted by a funeral home to arrange for the opening and closing of the grave for a family. Respondent stated this was done, but due to misinformation, the funeral home did not realize they were responsible for the outside container and grave setup. Respondent stated when they were contacted on the day of the service, they immediately began trying to find a solution to the problem, including using a container kept at the cemetery for such emergency situations. However, unfortunately, nothing could be done that day in a timely manner, and the burial was rescheduled to the next afternoon. Respondent stated that they did not receive a message to call anyone back, and that neither did complainant ever called to confirm the opening and closing of the grave. Respondent concluded by saying that the grave had been opened in accordance with the signed interment order stating a concrete box was to be used. Based on the above, complainant has not provided evidence on part of respondent for a violation of applicable rules or statutes, and therefore we would recommend closure.
So if I read this right, the funeral home that did the opening and closing, they did not allow knowledge to the other funeral home that they would be responsible for the setup?
My understanding from reading it, and it's a little difficult because there is some context of the history of the cemetery that extends far beyond just the four corners of this complaint, but it seems that from what I gathered, the funeral home that respondent worked at operated under kind of just, these are the extent this got thrown into our lap. It's not our ordeal, but we're taking it up as a favor to the bankruptcy court and haven't gotten any support for it. They seem to have been under the, I don't know if it was an assumption or if it had maybe been communicated at some point, and this individual funeral director, who is the complainant, didn't get that information. I'm not entirely sure on that. They seem to have been operating from the kind of perspective of that it's well known within that community that this funeral home has been saddled with this additional responsibility, and that you only go to them for the opening and closing, that the other things need to be taken up elsewhere.
I think in this case, the funeral home that was responsible for the arrangements with the family things, it was their responsibility to ensure that the outer container was taken care of. Should have asked specifically if the outer container was going to be taken care of. And there's a hint there that everybody around that area knew that there was a situation with that cemetery to begin with. So, I mean, I agree that, the funeral home that provided the opening closing could have, they could have said a little bit more or indicated, but it's really the responsibility, in my opinion, of the funeral home providing the arrangements to specifically ask if it was going to be taken care of. That way they would have known whether they were going to have to take care of it or not. So I agree there's the funeral home that did the opening closing didn't break any rules or statutes. So I'm going to make the motion to go with the council's recommendation for closure.
Just one quick question, just from my knowledge. Do you know, as far as the concrete box, did the family end up having to pay for that, or do you know? I'm just curious. I'm just a curious question. Who ended up paying for it? I knew they had a contract back before everything fell through. So
I think so. I think this is one of those unfortunate circumstances from what I gathered. I don't know if they were able to pull anything together. The next complaint kind of deals with this a little bit. Just saying that I'm sorry that this happened. We're not the ones that were a part of that contract. You may just be out of that money because the former cemetery dropped the ball.
I'll second Mr. Berry's motion.
All right, we have a motion by Mr. Berry, a second by Mr. Lee to accept legal's recommendation of closure. Any further questions? If not, all in favor say aye.
Aye.
Any opposed? All right, number 11.
Number 11 is complaint number 2023-007481. Complainant alleged unprofessional conduct on behalf of respondent funeral director. Specifically, complainant stated that on February 17th, 2023, they arrived at the cemetery to bury the decedent. However, complainant stated there was no vault, just an open plot. Complainant stated that the man who had dug the hole was told that a funeral home had taken over the cemetery and claimed to have been allegedly told by respondent that it was not his responsibility. Since they were unable to bury the decedent, since there was no burial container, complainant went to the funeral home and claims that respondent told them that the cemetery had gone under several years ago and that this funeral home was not responsible for fulfilling previous agreements. Complainant alleged that respondent was, quote, uncaring and replied, quote, well, I don't know what to tell you, end quote, regarding the former contract. Complainant alleged that respondent was, quote, unwilling and uncooperative, end quote, and laughed when complainant told respondent he should be ashamed of himself. Further, complainant stated that they were unable to locate respondent's license and thus theorized he was not actually licensed. And as a note, the respondent is a licensed funeral director with the state of Tennessee. Respondent replied and provided a timeline of events stating that complainant contracted services with a separate funeral home. The funeral home contacted the funeral home he was employed at for an opening and closing for the grave. Respondent stated this was the only service conveyed to the funeral home and the only service that the funeral home is responsible for regarding that cemetery. On February 17, 2023 at 2 p.m., the funeral director for the funeral home called respondent's funeral home, stating that there was no setup or outer container on site. Respondent stated this was the first time he had ever spoken to or interacted with complainant or that funeral director, and again reiterated that the funeral home's only obligation was to arrange for the opening and closing and marking, and that no prior conversation regarding a contract for additional merchandise and services was ever had. Respondent stated the first contact they had with complainant and their family was when they first arrived at the front office. Respondent stated 5 to 6 people, all of whom were very vocally and visibly upset, quote, aggressively demanded, end quote, an explanation regarding the grave's preparation. Respondent stated they remained professional and explained that the funeral home acted only as a third party for opening and closing the grave. Respondent stated they explained the history of the cemetery and the past issues with the Perpetual Care Fund, and that the funeral home was only responsible for opening and closing and marking the grave. Respondent stated they politely shared that they could not immediately fix the issue regarding the outer container. Respondent reiterated that the family was extremely angry and had perhaps been misinformed as to the role of the funeral home. Respondent contends that the family remained, quote, hostile and combative in gestures, tone, and conversation, end quote. Respondent denies laughing or being disrespectful to respondent in any way, and that he simply could not fix the problem that was created by a cemetery that voided or did not uphold their contract due to misappropriate mismanagement. Based on the above, we would recommend closure.
Yeah, the unfortunate thing here is that the family suffered in this and was put into, a lot of stress and added to their grief when it was unnecessary if they would just been informed correctly on the front end of what the situation was. But I mean, I agree. Again, there's no fault in the other funeral home, and it's hard. He said as to how that message was delivered. But I'll make a motion to approve council's recommendation for closure.
Second.
All right, we have a motion by Mr. Berry to accept legal's recommendation of closure, a second by Ms. Haynes. Any further questions or discussion? All right, if not, all in favor say aye.
Aye.
Any opposed? All right, moving on to number 12 and 13.
All right, and the last two are represents. They involve the same individual, just on their funeral director and embalmer's license. They are complaint number 2020-078-181 and 2020-079-131. And this was presented quite a while ago as follows. This is an ex-employer complainant alleging unprofessional conduct and theft by the respondent. Specifically, the complainant states that in July 2020, they discovered that pre-need funds were not deposited within 15 days required by law. The complainant states that they confronted the respondent and admitted that they did not deposit the funds. The complainant states that the respondent paid back the missing funds and that in August of 2020, the respondent was terminated. The complainant states that they conducted an investigation, and in September of 2020, they discovered that an entire funeral file was missing. The complainant states that there was no record for any funds received by the family. The complainant states that they contacted the next of kin, who stated they paid cash up front and then made a check payable to the respondent. The respondent provided a lengthy response indicating the following. 1. The money from the first pre-need contract was stolen while in the respondent's care, and the respondent did not inform their ex-employer out of fear and shame. And 2. Respondent states that the consumer did not pay $400 cash up front and that all other payments were brought to the funeral home. This complaint was sent for investigation. In January of 2021, a board field investigator interviewed and obtained documents from the various parties involved. The board field investigator discovered that violations including that the respondent failed to deposit $6,100 of pre-need funeral funds within the 15 days required by law, plus $2,500 in another instance of pre-need funeral funds. However, the $2,500 was later paid to the funeral home and on the funeral account. Additionally, a consumer check for $1,300 was written to the respondent and deposited into the respondent's personal account. The respondent engaged in fraudulent and deceptive practices, and the board decision on that was authorization for a formal hearing, authorization for suspension of funeral director and embalmer licenses for a period of 12 calendar months, beginning on the first day of the month following execution of order, a civil penalty of $1,000, 10 hours of continuing education approved by the board, and successfully passed the tenancy laws, rules, and regulations examination via consent order. Additionally, the consent order shall include that the respondent cannot work, perform services, or be associated in any manner with a funeral establishment during the suspension period. So the update. On March 31st, 2023, respondents signed a form surrendering their funeral director and embalmer's license as offered resolution of the two open complaints, and legal would recommend for closure of both of these open complaints based on the respondent's surrender of both funeral director and embalmer's licenses.
So $1,000 was never paid.
It was not. Essentially, since recently, she signed a surrender form, and both of those that has been accepted and processed, and those licenses are now surrendered.
That's typically how the fines are handled in a situation like that. They're just forgiven if licenses are turned in.
Correct.
But if she did reapply, she would have to appear before this body, correct?
Correct. Yes, there are, I'd say, probably about 5 different things that would potentially catch that, even if there was a companion pre-need complaint opened, which there is a signed consent order on. And so short version is yes, if this respondent ever reapplied, they would have to come before the board and undoubtedly answer some questions.
Do we accept the council's recommendation for closure?
Second.
All right, we have a motion by Mr. Berry, second by Mr. Lee for closure of both of these complaints. Any further questions or discussion? All right, all in favor, say aye.
Aye.
Any opposed? All right, Mr. Bryant, thank you for a great report today. Any further questions or comments from you?
I do not have anything. Thank you.
Thank you very much. All right, we will move along to Mr. Gribble's Executive Director's Report. Good morning, sir.
Good morning, Mr. President and board members. First is a legislative update. I was still looking at the same bills that we've looked at for the last couple of months, but there is an update on the second one listed there, House Bill 0074 and Senate Bill 0255. Has to do with education and the high school equivalency. This was signed by the governor on April the 4th, so it will be assigned to public chapter. And basically what that does is, whether it's a GED, a high set, or anything that's equivalent to high school education, that no matter what the term is, it allows the people to move forward in that area. And then the last one that's listed is House Bill 0023 and Senate Bill 0027 regarding open minutes, not open minutes, but open meetings. there was an amendment added to this bill, and it passed the Senate as amended on April 5th, and it was placed on the regular calendar for the House for last night. I haven't checked this morning, so I don't know if it passed the House last night or not. Council will look at it. It may be that the amendment now it only applies to municipalities and county governments, and it may not apply to regulatory boards as it would have as the bill was originally written, because it was not the Senate passed the amended version and not the originally written. But once the session's over with, legal counsel will give us all the details that we'll need to know moving forward to make sure we do whatever we need to comply with state laws and rules. Licensee reports a report of license administratively approved by the executive director pursuant to board authority for the period of March 11, 2023 through April 7, 2023. And you have that list before you. It's one page. There are no closed establishments to report from the last board meeting. Since the last board meeting, no establishments have closed. Disciplinary action report is the report of consent orders have been administratively accepted but approved by the executive director pursuant to board authority, and as reported on the February 2023 disciplinary action report for the regulatory boards. Complaint report. As of April 6th, we had a total of 29 complaints, 13 related to the funeral director and/or embalmer, and 16 regarding an establishment. Board members, that concludes my report. I'll be glad to answer whatever question you might have.
Have either of you heard how the comical insurance bills?
Checking the website, it appears that these two that I mentioned are the only ones that are still active. Mr. Batson, the executive director of the Tennessee Funeral Directors Association, is present. I don't know if you want him to speak to his knowledge of those two particular bills or
I
not.
just know sometimes they can hold up in committees. Yeah. I hadn't looked. That was just a curiosity question.
Most committees are either shutting down or near ending or have closed. And if it usually, from what I've observed over the years, if they're not moving in pretty current now, that means that they're probably not going to. Of course, this is the first of a 2-year session, so anything that is introduced this year can come back up in January when they reconvene again in January and move to as well without having to have a new bill introduced.
I understand right on the open meetings, if that does pass, any of the documents that we have will be public or not.
We would need to see what form it passes in. It appears to me, and again, from my personal knowledge, it appears it got amended to where now it's only applicable to municipal and county governments, but I can be incorrect in that. And once that happens, then legal counsel will review what passes and advise us how to move forward.
Any further questions for Mr. Gribble?
Do we accept?
Right. I have a motion by Mr. Berry that we accept Mr. Gribble's executive director's report. Do we have a second?
Second.
All right, second by Ms. Haynes. Any further questions or discussion? All right, all in favor that we accept, say aye.
Aye.
Any opposed? All right, we'll move right along. Applications for licensure. Mr. Gribble, do we have any individuals or establishments?
There are none, no individuals or no establishments to appear before you today.
All right. With no individuals or establishments, we'll open the floor for any new business. Anybody have anything to bring forth today?
President, just a couple things informational wise. As you're aware, Mr. Rahm's term expired December 31st of 2022. And it's my understanding that process is working as far as a replacement. Obviously, there's nothing official, but I understand that process is working. So hopefully, in the not too distant future, we'll have a new member to represent West Tennessee. And also, you might recall we had mentioned some conference room renovations, and when we might need to do alternative meeting places during that process. And the last we've been informed is that this room will probably be renovated initially in August, and then the audio equipment maybe in November. Of course, that's a fluid, it's a moving target. There's nothing, if you recall, we first thought it was going to happen in May. So just want to keep that on the radar. At some point, we'll probably need to meet elsewhere if we need to meet that month. But we don't know if it is right now. We think it's first be in August, and then totally unsure, but just want to keep that in everybody's mind.
Thank you for those updates. Anybody else with new business today? All right. If not, we will accept a motion to adjourn.
So moved. Second.
I believe we got a couple there, Ms. Stevens and Mr. Berry. So all in favor at 11:25 to adjourn, say aye. Aye. Any opposed? Thanks, everybody.
Yay.